Section 6. Formation of the laws. 51. The formation of laws and decrees can proceed indiscriminately from either of the two houses, with the exception of those which arise from contributions or imposts, which cannot have origin except in the House of Representatives. 52. There shall be considered as incipients of law or decree, first, the propositions which the President of the United Mexican States may deem conducive to the general good of society, and as such, particularly recommend them to the House of Representatives. Second, the propositions or plans of laws or decrees which the legislatures may direct to either house. 53. All projects of a law or decree, without any exception, shall be successively discussed in both houses, observing in each with exactitude the rules relative to the form of debates, interval, and mode of proceeding in discussing and voting. 54. The projects of a law or decree rejected in the House, where it originated, before being sent to the other House, shall not be renewed in the same House, by its members, in the sessions of that year, but must remain until the following. 55. If the project of a law or decree, after having been debated, should be approved by the absolute majority of the members present of both houses, it shall be passed to the President of the United States, who also, if he approve it, shall sign and publish it, and if not, return it, with his observations, within the term of 10 days, Sundays, and solemn festivals excepted, to the House of its origin. 56. The project of a law or decree, returned by the President in conformity with the preceding article, shall be a second time discussed in the two houses. If in both of these it should be approved by 2/3 of the members present, it shall be again returned to the President, who, without excuse, must sign and publish it. But if it was not approved by the vote of 2/3 of both houses, it cannot be renewed in either of them until the next year. 57. If the President does not return any project of a law or decree within the time prescribed in the 55th article, it shall, from that circumstance, be considered as sanctioned, and as such shall be promulgated, unless in the meantime the session of Congress should be closed or suspended, in which case the return must be made on the first day in which Congress shall be reassembled. 58. The project of a law or decree, totally rejected for the first time by the House to which it has been sent, shall be returned with their observations to the one in which it originated, if after a re-examination the said House shall again approve of it by a vote of 2/3 of the members present, it shall be sent a second time to the House that rejected it, who cannot a second time reject it without the concurrence of 2/3 of the members present. 59. The projects of a law or decree, approved of after a second revision by 2/3 of the members of the House, where it originated, and not rejected by 2/3 of the members of the other House, shall be sent to the President, who shall sign and publish it, or return it within 10 days, Sundays, and c. or etc. accepted, to the House, where it originated, with his observations. 60. The project of a law or decree, which, according to the foregoing article, the President returned to the House of its origin, shall be again taken into consideration, and if this approve it by a vote of 2/3 of the members present, and the revising body does not reject, by an equal number of its members, it shall be returned to the President, who must publish it. But if it was not approved by the vote of 2/3 of the House of its origin, or was rejected by an equal number of the revising body, it cannot be renewed until the ordinary subsequent sessions. 61. In the event of the rejection a second time of the revising body, in conformity with the 58th article, the project shall be considered rejected, and cannot be reconsidered until the following year. 62. In the amendments which the revising body make to any project of a law or decree, there shall be observed the same formalities required before the project of a law can be sent to the President. 63. The parts of a project of a law or decree rejected for the first time by the revising body shall take the same course as those totally rejected by it for the first time. 64. In the interpretation, modification, or revocation of the laws or decrees, the same requisites shall be observed which are prescribed for their formation. 65. All resolutions of the General Congress communicated to the President of the Republic must be signed by the President of both Houses and by a Secretary of each of them. 66. For the formation of every law or decree, it is necessary that an absolute majority of all the members of each House should be present in their respective Houses. Section 7 of the time, duration, and place of the sessions of the General Congress. 67. The General Congress shall meet every year on the first day of January, at the place designated by law. Its internal rules shall prescribe the previous forms necessary at the opening of its sessions, and the formalities which are to be observed at its installation. 68. The President of the Federation shall assist at the installation, and pronounce a discourse analogous to this important act, and the person who presides in Congress shall answer it in general terms. 69. The ordinary sessions of Congress shall be daily, without any other interruption than that of the days of solemn festival, and in order to adjourn for more than 3 days, the consent of both Houses shall be necessary. 70. Both Houses shall reside in the same place, and cannot move to another, without first agreeing on the removal, the time, and manner of effecting it, designating the same point for the reunion of one and the other. But if they agree on a removal, and differ as to the time, mode, and place, the President of the state shall determine the difference, electing one of those in question. 71. The Congress shall close its sessions annually on the 15th day of April, with the same formalities as are prescribed for its opening. Proroguing the session 30 days, Sundays, and solemn festivals excepted, when they may deem it necessary, or when the President of the Federation requires it. 72. When the General Congress is assembled for extraordinary sessions, it shall be formed of the same representatives and senators as the ordinary sessions of that year, and shall occupy itself exclusively on the object or objects for which it was convened. But if these should not be completed on the day in which the ordinary sessions are to commence, the extraordinary sessions shall cease, and the subject pending shall be determined by Congress in said ordinary sessions. 73. The resolutions that the Congress takes relative to the removal, suspension, or prorogation of their sessions, agreeably to the 3 preceding articles, shall be communicated to the President, who shall cause them to be executed without making any observations upon them. Title 4, Section 1 of the Supreme Executive Power of the Nation. 74. The supreme executive power of the Federation shall be deposited in one individual, who shall be styled President of the United Mexican States. 75. There shall likewise be a Vice President, on whom will devolve the faculties and prerogatives of the President in case of his physical or moral inability to serve. 76. To be President or Vice President, it is required to be a Mexican citizen by birth, 35 years of age at the time of the election, and to be a resident in the country. 77. The President cannot be re-elected for this office until after 4 years are passed from the time of his retirement. 78. He that is elected President or Vice President of the Republic shall accept these offices in preference to any others. 79. The first day of September, anterior to the year in which the new President must enter on the exercise of his duties, the legislatures of each state shall elect by an absolute majority of votes 2 individuals, one of which, at least, must not be a native of the state that elects. 80. The voting concluded, the legislatures shall remit to the President of the Council of Government a legal return of the election, in order that he may give it the course designated by the rules of the Council. 81. The 6th of January afterwards, the said returns shall be read in presence of both Houses united, provided those of 3/4 of the legislatures of the state have been received.